everybody. Again, my name is Maxine Lynn. I am an attorney licensed in New York and Illinois in the United States. Today we're going to talk about global aspects of the law that affect sex tech companies. So without further ado, here we go. So the roadmap for today's presentation is we are going to start with censorship. We're going to go over FOSTA SESTA in the United States, UK age verification in the UK as part of that discussion. Then we're going to go on to basics of protecting technology. We're going to talk about patents and morality clauses in that section. We're going to talk about how to choose a name. We're going to talk about trademark and, again, morality restrictions in that discussion. Finally, we'll get to data use disclosure and security. We're going to talk about the EU GDPR and privacy policies in general. And then we'll close out with copyright. We'll talk about filing for copyrights, the Digital Millennium Copyright Act, and we'll touch on the EU Copyright Directive. So here we go. Government censorship. So in the United States, in April of 2018, the government passed a law known in short as FOSTA or FOSTA SESTA. It stands for the Allow States and Victims to Fight Online Sex Trafficking Act. This law provides that if an interactive computer service with the intent to promote or facilitate prostitution or sex trafficking of another person, or acted with reckless disregard for such on their site, they can be liable for civil or criminal penalties. Violations may result in the imposition of fines and jail time for up to 25 years. So there's a lot to be afraid of here. It basically requires website providers censor communications on their website. If the website provider, any website provider, it could be YouTube, it could be Facebook, it could be, so it doesn't necessarily have to be an adult-focused website. They can be liable if, for example, there's a solicitation of prostitution through a messaging system on their website. Many adult websites in the United States have shuttered due to this law. To my knowledge, no prosecutions have occurred yet, but they may eventually come. And the law has made it very difficult for adult industry companies to operate because it's a lot harder to obtain capital, as an example, when you have this looming possibility of such liability over you. The good news is that the law is currently being appealed in the United States in the court system. So it is possible that it could be struck down, but right now it's still on the books, and we'll have to wait and see what ultimately comes of it. Age verification in the UK. So the Digital Economy Act, it requires age verification for porn sites that are accessed in the UK. It was actually supposed to start being enforced as of today, but it has now been delayed another 6 months. The British Board of Film Classifications is the regulator, and a company can be fined up to £250,000 for non-compliance. So it's another really big deal law that affects adult industry. There's a lot of teeth to this law because the UK government can tell a company's ancillary service providers not to allow them to not to give them credit card services, for example. So you're an adult industry company, you have a porn site. A child accesses the porn site because you don't have proper age verification systems in place. You can wind up, the government of the UK can actually tell MasterCard or Visa not to allow you to have access to those services anymore. So they can cut your entire business basically throughout the world, not just in the UK, because if MasterCard pulls out, that's all over the world. So this is something to really pay attention to and watch. In addition, this is probably going to become a model for other countries. As the UK starts to work out the kinks, and there's definitely going to be issues that are going to occur once it's actually goes into force. Once that happens, other countries around the world are going to be watching. And you're probably going to see other laws in other countries start to pop up that look similar. So it's not really something that we can run from by just geo-blocking the UK. For now, companies can do that, but in the future, that's probably not going to work if other countries adopt similar laws. And the sad part is that, of course, we can all agree that children should not be accessing pornography online. However, the problem with a lot of these things is, like, you may have a sex education site. You may have something that is not technically pornography, that is educational, but has maybe some nudity or has some images that you know, are not necessarily pornographic, but they show a naked body. Or your text, the keywords can be picked up in the text, winds up blocked. So it may wind up blocked, and so you're going to wind up having a lot of issues potentially with even sex education sites being blocked, which we don't want. So it'll be interesting to see what actually happens and how the kinks are worked out of this law as it progresses forward. So here we go with patents. Protecting your technology is very important in the sex tech field. So if you have a new technology, you can get what's called a patent. So a patent is a document granted to a person or a company, giving the owner the right to prevent others from making, using, or selling your invention. And protection lasts up to 20 years from your filing date, or your application date, I'm sorry. So examples of patentable subject matter include like sex toys, methods of making condoms, lubricants, VR cameras, software systems, and much more. So any type of technology, and in some cases software can be patented. And if it's something new, you want to definitely look into this because it's a really great way to deter competition. Now, this is something that's not talked about very often in general seminars on intellectual property, but here this is very relevant. Morality clauses relating to patents. So in some countries, it is considered, so sex toys are considered immoral. They're considered against the public interest, and therefore they are not allowed to have patents on sex toys. India and China are examples of major markets that include a type of law like that. And the International Treaty on Patent Law, in short, is called the TRIPS Agreement, trade-related aspects of intellectual property rights, permits member states to have an exception for inventions against the moral compass. So the United States, the European Union, Australia, Canada, they are examples of countries that do not have morality clauses at this time, and you know, your sex toys should be protectable. Trademarks. So trademarks are words, symbols, designs, anything used to uniquely identify the source of your goods or services. Trademark protection should be considered for any product or service. So if you have a startup, you really should take a look into checking into whether your name is protectable, because you don't want somebody, if possible, you don't want somebody to use a name that's really similar to yours in the same field, because there could be confusion. So here's an example. Tantus is, the name of a company. They sell sex toys under that name, and they have a trademark registration. So now we get to trademarks on morality. Similar to patents, many countries around the world do not allow trademarks that include sexually explicit terms or images, and so that can create problems for adult industry companies that have an explicit word or image in their brand. So far, it's been very hard for them to protect their names. However, there's been a major change just last week in the United States. The highest court in the land, the U.S. Supreme Court, held a law that banned scandalous or immoral trademarks, which is usually what explicit marks would fall under. They held the ban on that unconstitutional. So the ban did not allow registration of scandalous or immoral marks on the trademark registers. And now this ushers in a new era for adult brands in the United States, because now companies that have explicit names can get the same trademark protection as a company in mainstream. They can get the same benefits of protection of their name. Without the possibility of registration, it's a lot harder to enforce a trademark. So this is really, really big news in the US. The thing to remember, though, when choosing a name is that we're working in a global market today. So if you're thinking of using an explicit term or image in your name or in a product name, consider the global aspect, because if you're also going to be operating a lot in Europe or in Australia or in Asia, not just in the United States, you may want to look at the laws of the other countries or regions, because if you can just protect it in the US and not somewhere else, that might not be the best way to go. Personal data use and sharing. So here in the EU, you have the General Data Protection Regulation. This just went into effect recently. It is a sweeping regulation on data protection and privacy for EU residents. It sets very strict standards on how companies can process personal data of EU residents when it's collected online or other electronic means. So it's a pretty big law. There's a lot to it. I'll give you a brief summary of things to think about. Affirmative consent is required to process a person's data under this law. So the person has to, if you're going to collect data, you might want to collect the name and address of someone, or you might want them to fill out a survey. If you're going to collect data that's personally identifying, the person needs to give you affirmative consent. They need to affirmatively check a checkbox or type it in or whatnot. It can't be passive, like the checkbox is already checked and then they click the submit form. Like, it shouldn't be automatically checked. So again, affirmative consent. The person has to affirmatively tell the company that their data can be collected. The GDPR requires disclosure of how the data will be collected, how it's going to be used by the company, how it might be shared by the company. So all of this has to go into the privacy policy, typically on the website. So if you're an EU resident, if you want to see how your data is being used or shared, you can look at the privacy policy of the website usually. If you're a company, working in the sex space, on the flip side, pay a lot of attention to the GDPR, because your privacy policy really needs to be in compliance as much as it can be, because there's really big fines associated with non-compliance. So the law necessitates that companies provide a copy of any data collected upon request. It also includes a right to be forgotten. So if you're running your company and somebody sends in a message that they want their data, whatever was collected, deleted, you have to delete it. And organizations can be fined up to 4% of annual global revenue. Annual global turnover is the term, or 20 million euro for violations. So there's a lot at stake. So keep an eye on that. Now that's the EU. That's applicable to EU residents. But data privacy is important around the world. A very well-known sex toy company was sued in the United States recently, and it was settled in March of 2017 for 5 million Canadian dollars. The only thing they did wrong was not state in their privacy policy that they were collecting user data. They weren't doing anything wrong with the data. They weren't selling it. They weren't sharing it, to my knowledge, but they were collecting it for analysis, and they didn't disclose it in the privacy policy, and that was what got them. And it wound up settling. So there was never an admission of guilt, but it wound up costing the company a lot of money. So make sure that your privacy policies are written or reviewed by an attorney as you move forward in your business. It's important around the world, not just in the EU. Copyrights. Anybody who is in adult entertainment definitely wants to pay attention to this. Copyright protects original videos, photos, text, graphics, books, website content and code, advertisements, it gives the copyright holder a lot. A registration affords somebody a lot of rights. So copyright gives the owner the right to reproduce the work, the right to prepare derivative works, which means basically modified works. It allows them to be the only person to distribute copies of the work or to perform or display the work publicly. So you don't necessarily have to have a registration to have those rights, but a registration allows you typically to collect a lot more damages in the case of infringement, and it also it makes the process of proving infringement simpler. So you want to file for copyrights at least every 3 months. So if you are creating content, for example, if you're creating porn videos, you're creating educational content, you want to file copyright registrations at least every 3 months. This is critical if you want to pursue an infringement action, at least in the United States. In the United States, you have to have, in order to gain a lot of the benefits of the copyright registration, you need to either have you have to have either copyrighted it before. I'm sorry, I'm tired. You have to have either registered within 3 months of publication of the work, or you have to have registered prior to the infringement. So a good rule of thumb is register everything every 3 months. I mean, everything that you've come up with in the last 3 months, each 3 months. And another reason that copyright registration is important is for the Digital Millennium Copyright Act, known in short as the DMCA. The DMCA is a safe harbor. So it provides a safe harbor to relinquish a website operator from liability for copyright infringement by users on its website. So for example, you'll see on Facebook, you'll see on Twitter, you'll see on most websites, at least that have a big presence in the United States, you're going to see a DMCA policy. So this allows them to remove themselves of liability in the case that a third-party user commits a copyright infringement on their website. So so basically, if you're going to have a website where, for example, you're allowing people to either send messages, do post clips, images, anything like that, you're going to want to have a DMCA policy, and you're going to need to enforce that DMCA policy. So basically, you have to look at the letter of the law, but basically you have to have a policy where a copyright holder can connect with you, can contact you, flag the copyrighted work, and ask you to take it down. And if you take it down within a certain amount of time, then you, as the website owner, will not be liable for the infringement. So that's a really important thing if you are a digital content sharing service. Again, you're going to allow people to post or share on your website. And last but not least, on the subject of copyright, the EU Copyright Directive. Over the last couple of decades, the EU, just like the US, has shielded digital content sharing services from liability for copyright infringement on their websites. Well, a lot of this is going to be changed in the EU. Article 17 of the EU Copyright Directive, ratified by the Council of the European Union this past April, has changed the game. Article 17 shifts the burden of flagging copyright infringement from the copyright holder to actually the online content sharing service. According to Article 17, online content sharing service providers will have to act to ensure copyright infringement basically does not occur at all on their websites, rather than reacting with the notice and takedown like we just talked about. Instead of having to remove content to take away their liability, they basically are required to not have any infringement on their site at all, which is kind of an impossible burden. But that's basically what the law says, and it's not the exact language of it, but that's what it comes down to. The good news is for small startup companies, there are some exceptions outlined for companies that are starting out and aren't making a lot of revenue. And it's a directive. So it's not law, it's a directive, but the member states of the EU are going to pass legislation within the next 2 years that's going to comply with this directive. So it's going to be important to watch because this is a huge deal, even for mainstream. I mean, for anybody that is a digital content sharing service, to have this kind of potential liability now that this law creates is a really big deal. So keep an eye on it. And just a reminder, none of this was legal advice. It was meant to be an overview. And if you need any legal advice, consult an attorney. And I'll be around if you have any questions. Thank you so much for coming.